Assalamualaikum, I'm HUSNA binti MAZLAN, matric number SA1930. Today, my teammate and I will present about the case law. Firstly, I want to present about general principle. The general rule is that an agent cannot sell goods without the principal consent. If the agent does so, it is considered a breach of contract. The principal can claim the loss from the agent as he has breached his duty as an agent. However, in this situation, the agent action is necessity to prevent loss to the principal with respect to the goods. To prevent from damage is accepted. Agents have the authority to take any and all action necessary to safeguard their principal from harm in an emergency that will be considered prudent in their own situation. When someone is trusted with another person's property and it's become necessary to take action to protect it, even when he lacks express permission to do so, this arises. The principal and the person acting on his behalf must already be parties to written contract. Three requirements can be satisfied. The agent is unable to get the principal approval that the activity taken by the agent are necessary and that the agent acts faithfully. But from this case, the agent must communicate first to the principal as an agent cannot sell goods without the principal consent. If the agent does so, it is considered a breach of contract. The principal can claim the loss from the agent as he has breached his duty as an agent. That's all from me. Thank you.
Hi, my name is NORHAYATI binti ARAJAH with the matric number S63317. Next, I will present about the section of the law in this case. According to the section 142 of the Contract Act of 1950, an agent has the right to take all the measures necessary to safeguard his principal from loss in an emergency that would be considered prudent in his own situation. Under Section 74 of the Contract Act of 1950, a party that is not in breach of a contract may be held liable for damages. The losses could be a little or severe. When the innocent party has not experienced a loss as a result of the other party's breach, nominal damages are given and substantial damages are given as monetary compensation for losses incurred as a result of the other party's breach. An innocent party must demonstrate both the remoteness of its loss and the magnitude of its loss in order to establish substantial damages. The burden of proving that the innocent party failed to lessen his damage rests with the party in breach. This is a discretionary equitable remedy offered by the court. As in Section 57, Bracket 2 of the Contract Act 1950, a contract to do an act which after the contract is made become impossible or by reason of some event which the promiser could not prevent unlawful becomes void when the act becomes impossible or unlawful. In Section 57 also state if there is an impossibility of the performance after contract has been made by the occurrence of some event which radically changed the circumstance contemplated by the parties, the contract is discharged. However, there is an exception to this rule if Chong sold the durian without communicating to Ibrahim. According to the case, Chong does not have the authority to do so. This is because it is impossible for the Chong to communicate and get further instruction from Ibrahim. According to the Section 167 Contract Act 1950 about an agent's duty to communicate with principal, which is, it is the duty of an agent, in cases of difficulty, to use all reasonable diligence in communicating with his principal and in seeking to obtain his instruction. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Fatma Zuhra binti Maisa. My matric number is SC2513. I will present about the fact of the case. In this case, Chong sold durians at a low price without Ibrahim's consent. He violated Section 167 of the Contract Act 1915, which is the agent must try his best to communicate with the principal. But Chong decided by himself to sell the durians at a low price at the roadside as they are stranded in the flood. He did so because the traders in Singapore will not accept the durian which is cracked, overripe and unpalatable. The agent's duty as a Section 164 Contract Act, agent must try his best to communicate with the principal. He must use all his skill and diligence in giving any information to or getting any instruction from the principal. The sale of the durians without Ibrahim's consent will be considered a breach of contract between Ibrahim as the principal and Chong as the agent. So, Ibrahim can claim the loss from Chong as he has breached his duty as an agent.
Hi, Assalamualaikum. My name is Siti AZIRA binti SUKRI. My metric number SC1922. Today I want to present about analyze or application of the law. Springer v. Great Western Railway Company 9021 1KB 257. In Springer v. Great Western Railway Company, the plaintiffs allege that the defendant failed to communicate with the plaintiffs during the shipment of tomato from Channel Island to London. The plaintiff sought damages, arguing that the defendant had not communicated with the plaintiffs during the shipment, resulting in no agencies of necessity. In Prager v. Blackspear, Stand Hand Court Ltd. during First World War, a farmer's agent bought 1,900 worth of skin, but could not dispatch them due to war. The skin value increased and the agent sold them, arguing there was no agency of necessity. Tan Chiu Tu V. Asu. For example, matters respondent can claim actual and special loss due to delayed delivery of metal melting furnace with no indirect or remote loss damages.
Hi, Assalamualaikum. My name is NAJIHAH binti at 62807. In conclusion, Chong did not have the authority to sell the durian without communicating with Ibrahim, because it would have been possible for Chong to get the instruction of the owner durian by sending a message or WhatsApp or by calling the owner. Even though Chong had a good idea to sell the durian at the roadside at a cheap price, Ibrahim had been contracted to carry the durian and not to sell the durian. If Ibrahim suffered a loss as a result of Chong's action, then Ibrahim may be able to claim the loss from Chong. To give them the right to sell the durian, the circumstance must exist which put them in the position of agent of necessity for the owner, as Chong could have communicated with the owner. There was no agency of necessity. Chong had breached the contract and was liable for damage. It is important to note that this is a complex legal issue and it's best to consult a lawyer for specific legal advice. In conclusion, the owner, Ibrahim, can claim damage from the defendant, which is Chong. That's all from us. Thank you.